Mr. Bailey, can I just mention,
Yes.
when we were looking at Lawrence, I had in mind there was a more recent case on the point, which there is. Don't look too alarmed. I'm not sure it undermines your submissions, but there's a decision of the Lady Chief Justice in a case called RVBVA, very helpfully, which is 2025 EWCA Crim 1359, which trots through the authorities and applies it in the context of filming a sexual assault, and their non-consent to the filming was held to vitiate consent to the sexual act.
Right.
What I've taken from it is, apart from the suggestion that all the authorities are quite difficult to reconcile and would be subject to criticism, that it all turns on Section 74 of the Act rather than common law, and that the broad test is whether there's a sufficiently close connection with the sexual act. So I'm not sure it undermines your submissions, but I thought I should mention it since it's...
Well, Lord, I'm much obliged. Can I apologise for the fact that we didn't identify that from our own researches? I obviously will look at it. I mean, if I may, I doubt I'll have anything, given what your Lordship said, to say, but if I could just reserve the possibility of doing so very briefly. I mean, only say that because I haven't looked at it.
That's why I'm mentioning it.
Yes. Obviously, also the tort cases are also, we would submit, instructive. And of course, the Section 74 point, I completely understand that, and it's not a perfect parallel. I think that the submission I was endeavouring to make was that the distinction I sought to draw between a lie which deceived the representee into not believing that there was a breach of trading warranties going to happen is different to one that relates to the consequences of the breach happening. As I say, I submit that distinction is sound analytically, independently of any other authorities. And I was only relying upon the criminal cases and the tort cases as illustrations of the fact that not all lies negate consent, and there has to be something that links it to the act itself in order for consent to be negated or vitiated. It doesn't really go beyond that, but nonetheless they are instructive in my submission, given the fact that we're dealing with the notion of consent to a breach of a trading warranty. It's not a wrong in a criminal sense. Breach a trading warranty isn't a criminal offence, but it's nonetheless a contractual wrong of a sort, a breach of warranty. So that's why there is some benefit in having regard to that analogy. Well, that brings me, if I may, to the fortuity, the final three grounds of appeal. Now, on this part of the case, as I understand it, there's no dispute between my learned friend and I on what the relevant principles of law are. They were articulated by Mr. Justice Hobhouse, as it then was in the Wondrous, and they were explained by Mrs. Justice Dias in the win-win, the DLOS case, which I believe came to the Court of Appeal not on this point, and I think, if I can remember correctly, at least two members of this panel were involved in that appeal. The fortuity point was the first point Mrs. Justice Dias dealt with, and permission to appeal wasn't allowed on that ground, which is why the Court of Appeal didn't consider it. But we have heard judgment on this point in Bundle 2 of the authorities, at tab 25. In fact, yes, both Lord Justice Mayles and Lord Justice Popplewell were on the panel of the appeal in this case. But as I say, the point on fortuity was not one of the issues that was taken on appeal. As far as the law is concerned, Mrs. Justice Dias picks that up at page 600 in the bundle, which is page 542 of the internal pagination of the case. Where she says, paragraph 75, it's not controversial that insurance is concerned with a risk or uncertainty of loss. This does not mean that coverage is limited to events which are unexpected or unforeseeable. It can include loss caused by events which are both probable and foreseeable. Nonetheless, it does not protect the assured against losses which are certain to result or which are caused by ordinary wear and tear or are deliberately caused by the assured and it is in this sense that it is said that a loss must be fortuitous in order to be covered. And then moving forward, if I may, to paragraphs 88 to paragraph 90 on page 602, having referred to Miss Hopkins's submissions, she says, paragraph 88, with the greatest respect to her arguments, however, which were most skillfully and attractively presented, I am unable to agree. In my judgment, what Mr. Justice Hobhouse, as he then was, had in mind, was loss which was bound to result from the conduct voluntarily entered into, quote, by the choice of the assured. In the case of port dues, it is invariably the case that worldwide that a vessel will not be cleared and allowed to leave port unless they are paid, and any owner will know this. On the facts before him, therefore, it could properly be said that the detention was the ordinary consequence of the owner's deliberate and voluntary choice not to pay. The decision in the Wondrous, therefore, says no more than that consequences which can be expected to flow in the ordinary course of events from a deliberate choice made by the assured are not fortuitous. As so stated, the proposition has two aspects. There must be some choice by the assured, and B, the consequences must be such as to flow in the ordinary course of events. And then she elaborates on what those two factors mean. In paragraph 90, she says, as to the first of these, the concept of choice implies awareness that a decision is being made between two or more options which are different in some relevant sense. And if you go over the page, paragraph 92, she says, as to the second aspect, which must mean B, in paragraph 89, as to the second aspect of the proposition in the Wondrous, it seems to me that the situation which Mr. Justice Hobhouse had in mind was akin to one of inevitability. And there's a point about whether you have to subjectively be aware, and she says you don't. But what it boils down to, in my respectful submission, is that the principle at play here can be stated shortly in the following terms. A loss will not be fortuitous if it is the inevitable consequence of a choice made by the assured between two or more options which are different in some relevant sense. That's the proposition of law which is relevant here. Now, the judge dealt with the fortuity defence at paragraph 82 of her judgment, I believe.
Before we leave the law, there's quite a discussion about inevitability and fortuity, particularly in the Sawyer and White case in the context of inherent vice, where Lord Justice Donaldson said that you can insure against something which is in fact inevitable, and the test might be perhaps better expressed as
known certainty of loss.
Known certainty of loss.
Exactly.
But both he and I think Mr. Justice Hobhouse, as he then was in the Wondrous, said in each case it's subject to the terms of the policy, and you can insure against it, but you have to look at the terms of the policy, and therefore I don't want to detain you on your argument, but there might be a question as to whether, if you're not right about privity and the loss otherwise falls within the terms of the policy, it doesn't matter how certain it was to the knowledge of either party. It's still covered by the terms of the policy.
Well, I suppose that the win-win, the delos, what Mr. Justice Dyer says is that the knowledge of the parties is irrelevant. You don't need to show any subjective knowledge. It just needs to be the inevitable consequence, irrespective of what they knew.
Well, what Lord Justice Donaldson says on the basis of a number of cases is you can often have insurance on something which in fact will inevitably occur if, so far as the parties are concerned, they don't know whether it's going to occur or not. So inevitability is not divorced from knowledge of the parties.
Well, my lord, I do see that. Your lordship's opened up if I may say so, one of the most interesting, difficult areas.
It is a difficult area. It is a difficult area.
There's a very interesting lecture given by the previous Chancellor on this very topic, and of course we have Lord Mance saying, "What's the position if a bomb is put onto a plane, and the loss is going to be inevitable if it blows up when the plane takes off.
No.
And nobody's even answered these questions.
No.
I agree with you, if I may respectfully say so, that what Lord Justice Donaldson says about known certainty of loss is, I would respectfully submit, the law,
Yes.
the correct.
I think it's the sort of conventional view.
Correct view. The point I think your lordship's putting to me is, well, if you're wrong about privity, how is this going to help you? And I think the answer, if I may say so, to that is there is a subtle difference between the fortuity point and the privity point in this sense. Namely, for the purpose of fortuity, all that I need to show is that the assured knew that it was inevitable that by going to Ukraine, there would be a breach of the trading warranties in the war risk policy. In other words, why it agreed to going to Ukraine, whether it was induced by, whether it wouldn't have consented because of the lie it was told about the DAC, all of that, in my respect, is actually irrelevant to the fortuity defence. All that matters is the fact that it was an inevitable consequence of the voyage to Ukraine that the war risk policy would inevitably not respond to a loss because of the breach of the trading warranties.
The point I'm putting to you is, if that doesn't amount to privity and the terms of the policy are otherwise complied with, why doesn't it come within the caveat that Justice Hophouse provides, that this is just a general rule, but it depends on what the policy covers?
Well, I understand that, but if the policy, the proviso, and the argument about the proviso is whether or not there was consent, whether the consent to go to Ukraine was negated or not. Where here, we're not looking at the question of consent to go to Ukraine. We're looking at what the consequences are going to be.
I understand you say it's a different test.
Yeah.
But if it's a different test, and what you're seeking now to apply is some general principle of insurance law,
yes,
rather than the terms of the policy, there is a question, at least in my mind, as to whether, if the terms of the policy cover the loss, there is some general principle of insurance law which overrides that. That's the way
I'm so sorry.
I'm not saying the answer is necessarily clear one way or another, but that may be a question that arises.
Well, my lord, I appreciate that. And I'm sorry if I misunderstood your question, and now I clearly do understand it. And my respectful submission, the point of principle I'm relying upon is independent to the precise terms of the policy. It arises as a matter of general principle of insurance law. And
do we need to look at what Mr. Justice Hophouse said in the Wanderers? Because I think he did qualify it, if I remember rightly. Remind me where we've got that. Tab 14. I'm sorry to blow your course so early.
no.
It's part of your submissions. Page 225. I may have overstated it. Where is it? Top left of page 225. Where a situation comes about as a result of the voluntary conduct of the assured, not normally be described as fortuitous. Didn't happen by chance, by choice of the assured. Be in the ordinary course. But if the owners of the vessel don't pay the port dues, the vessel will not be cleared. For the purposes of the law of insurance, in the absence of an express agreement to the contrary, a policy should not be construed as covering the ordinary consequences of voluntary conduct of the assured, arising out of the ordinary incidents of trading. It's not a risk.
Yes.
And that's what I had in mind.
Well, yes, I was aware of that, but that, if I may say so, that's what Mr. Justice Hophouse is saying, is that unless the policy actually expressly provides to the contrary, i.e. that we are going to cover you for what in a sense are inevitable consequences of deliberate choices, then the presumption is that they're not covered. Now, I don't duck the fact, which I thought your Lordship was focusing on, which is how does the fortuity defence tie in with the privity defence? And would it be odd if they weren't privy, but they somehow had made a choice which meant that the loss was not fortuitous? And my respectful submission, there, as I've tried to articulate, perhaps not effectively, but I tried to do so, was to say that there is a conceptual difference, because for the purpose of the fortuity defence, all I need to show, in my respectful submission, is that, and I'll accept it's a known consequence, that it was a known consequence of the choice that that Oceanus made, namely to rely upon the DAC rather than attempt to hold the vessel back, that by going to Ukraine, there would inevitably be a breach of the trading consequences, and therefore it was inevitable that if the vessel sustained a casualty whilst in Ukrainian waters, the war risks policy would not respond.
Yes, I understand.
That's the way I put it, my lord. The most formidable objection to the argument that I'm articulating is the one the judge took, which is that if I'm wrong about what the nature of the loss is that's insured, and if the learned judge was right to say that the insured loss is the proprietary interest in the vessel, then my argument completely falls away, because I totally accept that the mine strike was clearly fortuitous. But in my respectful submission, for reasons I tried to articulate this morning, the proper analysis of this contract is that the loss that's being insured against is a financial loss consequential upon the non-payment of a primary policy. And once that is understood, then it becomes clear, in my respectful submission, that if the non-payment by the war risks policy was inevitable as a consequence of a choice made by the assured, then the loss will not be fortuitous. And that's how we put the case. And that's independently from privity. As far as the choice is concerned, we've set out our case, I think, in the skeleton argument. In the core bundle at paragraph 67. So that's at page 41 of the core bundle. So we say the respondent did have a choice. It chose to allow the breach of trading warranties to occur by approving the December additional cover and not giving an order holding the vessel back. And then we make some points to demonstrate that. And although we rely upon all those, the key one I think is section 67.2. The contemporaneous exchanges make clear no need to hold back the vessel. And I just wanted to show you actually what those exchanges were, because they are, my submission, quite clear, and they're in the supplemental bundle at tab 27. And as so often happens, because they're an email exchange, one has to look at the last page of the clip first and then work backwards. So go to page 129. It starts, so it's December the 26th, and this is after Wilma got the cover note, the December additional cover note by WhatsApp. He then downloaded it and forwarded it to Trine, and that she replied saying, we want to see the LPC, that's the loss payable clause. And then over the page, at the bottom of page 128, Wilhelm then says this: "Hi Trine, understand the wishes, but given the time frame, her vessel going to Ishmael tomorrow, we're on a need to have basis. So, question is the vessel insured for Ishmael calling? Reason asking is, should we hold vessel back by instruction, or are we okay and a need to have on the current cover note? So he expressly articulated the choice that Oceanus had, having been provided with a draft copy of or a copy of what turned out to be the forged DAC. He says, should we hold the vessel back by instruction, or are we okay from a need to have on the current cover note? And the answer comes back from the insurance brokers on which Wilhelm was relying. Dear Wilhelm, everything is in order. No need to hold back vessel, but would ask for confirmation of premium. Thanks, he will do. And we know that he then wrote to the to the manager saying everything okay. And they didn't hold or attempt to hold back the vessel. And that was the decision that was taken, not to hold back the vessel. But the inevitable consequence of doing that, of relying upon the DAC, meant that there would inevitably be a breach of the trading warranties because the vessel would be going to Ukraine. And the inevitable consequence of that was that the policy would not respond to a casualty as a result of that breach. And if, therefore, I'm right in submitting that the proper analysis of the policy is that the loss insured against is the financial loss consequential on the non-payment by the underlying primary policy, that loss, in particular, any non-recovery under the war risks policy, was a known inevitability from the perspective of the assured. And it doesn't matter, in my respectful submission, the fact that the judge found that even if the owners had given a holdback order, she found it probably would not have been complied with, is what she said. In other words, it's more likely than not that the vessel would have gone to Ukraine even if Wilhelm had attempted to hold back the vessel. Now, the reason that doesn't help is because the loan judge's finding, of course, this is a hypothetical counterfactual scenario. Her finding about probably what would have happened means that there was a possibility consistent with her finding that the vessel wouldn't have gone to Ukraine. It probably would, but possibly wouldn't. But the effect of the choice that was made by Oceanus, by not even attempting to hold the vessel back, but by agreeing to rely upon the DAC, meant that it was inevitable that there'd be a breach of the trading warranties, because that was the consequence of the vessel going to Ukraine.
But a breach of the trading warranties wouldn't inevitably result in a loss to Oceanus, would it? There would have to be a casualty.
Yes, there would have to be a casualty.
So if you need two things, you need a casualty and the owner's insurance is not responding. One of them is fortuitous. If that happens, the second is then a certainty. Is the loss still not fortuitous? It depends on there being a mine strike. Well, a casualty.
My lord, if that's right, my lord, if it's right to say the loss is to be regarded as a composite loss, of which there is the requirement both of the damage to the vessel and the non-recoverability, Lord, I think you're right, my lord. Yes.
But there is a requirement of both, isn't there? I know. We've been round what the insurable interest is and so on, but unless there's a casualty, there's no loss. Well, you can't claim on this policy unless there's loss or damage to the vessel.
Well, my lord, that's right. But the question is, what is the loss? What is the loss that's insured against? I accept that there is the prerequisite that has to be a casualty, but if there is a casualty, and there is damage to the vessel, but the second aspect of the requirement, namely the policy doesn't respond for a reason other than a peril, there's no loss. There's no insured loss within the meaning of the contract.
But if it's what you describe as a prerequisite to a claim, and that prerequisite only occurs fortuitously, is the loss not fortuitous?
Well, my lord, I think I've tried to accept, my lord, in answer to your question, that if it is properly to be regarded as a composite loss, your lordship's right. the fortuity point would.
Well, I'm not putting it in those terms. Assume that the perils insured against are only those which are identified in clause 2.1. It is, as you suggest, a policy against the financial consequences of the war risk policy not responding.
Yes.
What I'm putting to you is, it still is a policy against the against the war risk policy not responding to something, and the something has to happen in order for the loss, and the something is fortuitous. That's the casualty. Even if one frames it in your terms, the loss is fortuitous.
Well, I understand what you.
That's what I'm.
Sorry.
I'm trying to articulate.
Well, sorry. My answer to that, my lord, would be this: that when you look at the insured perils, so you try and draw the connection between the insured perils and what the insured loss is, it's clear from the insured perils that they're entirely focused upon the reason why the policy itself, the underlying policy, doesn't respond. Now, the way I would put it is that the loss is the failure of the policy to respond, although there's a necessary prerequisite to that, namely the occurrence of a casualty. The occurrence of the casualty is just a prerequisite. It's not the loss itself that is insured against under the policy. And the reason I say that is because it's clear from the perils, they're all solely directed at the question as to the reason the primary policy doesn't respond. And therefore, in circumstances where it was inevitable that if there was a casualty, the underlying primary policy would not respond because of the breach of trading warranties, that loss, in my respectful submission, is not fortuitous.
I mean, another way one might put the point I was making to you is that the choice to send the vessel to Ukraine didn't inevitably involve a loss. It might not have struck a mine.
Well, my lord, I understand that point, but what it definitely made inevitable was the fact that the annual war risks policy would not respond in the event of a casualty, and that was essentially what the loss that's insured against is under the policy, not simply property damage. Property damage may be a necessary prerequisite. It may be effectively a condition precedent, but it's not actually what's insured against. The insured loss is the failure of the primary policy to respond. And for that reason, the fortuity point operates even if the damage to the vessel itself was itself fortuitous. Yes, fortuitous. And the reason why, from a conceptual point of view, what the submission is sound is because it reflects the nature of the risk. The risk that the MII policy is endeavouring to insure against is the risk that the underlying primary policy doesn't respond. But it's that very risk that Oceanus was prepared to accept. Now, it was prepared to accept it, but only on the basis of the DAC. I completely understand that. But as I said earlier today, it put all its eggs in the DAC basket. The fact that the DAC failed the reason they don't recover is because the reason the DAC failed is not an insured peril. Forgery was not one of the risks that my clients insured against. Had the DAC failed for different reasons, namely avoidance for non-disclosure, for example, then my clients would have been liable. But that's not what in fact happened here. And that really, from a merits perspective, and I know we've touched on the merits, and the learned judge below was affected, asked me 3 times why, if Oceanus had been kept in the dark, why should they be any worse off because they were proactively involved? Well, the reality is that on the merits of the case, the real cause of the loss here, the real problem, the real reason Oceanus suffered a loss is because they were the victim of a fraud by their clients in being provided with a fake DAC, a forged document. That was the document that unlocked the voyage to Ukraine. But the fact of the matter is that my clients don't cover that risk. They don't cover the risk of forged documents. They cover named perils, including breaches of trading warranties and the like, but they do not cover fraud in the form of forging contracts of insurance. That is a risk that Oceanus bore when it decided to accept at face value the DAC. in the exchanges we've looked at this afternoon. Well, Lord, unless I can assist you. Yes.
Do we know that the fraud was one to which the owners were a party, or was it?
I think
just as of.
I think, in fairness, we don't know for sure. In fact, we don't know, in fact, whether it was the Azos or the charterers, or even possibly even the. I'm looking at Mr. Daniel right now, hoping to state correctly. I don't think we know for sure who was the author of the fraud. So perhaps when I said the owners, that was slightly wrong. It was, or their clients. What I meant, it was someone on that side of the fence who duped them into accepting the DAC. But that is simply not a risk that my clients agree to insure against. We don't insure forgery. And I mean, it is possible you could buy a policy which says any misconduct on the part of your assured or their servants or agents will carry that risk, but that's not this policy. It's a narrower named risks, named perils policy, which forgery is not one. And that's why, from a merits perspective, it's not surprising if this claim were to fail. In my respectful submission. Thank you. I hope that answers.
Thank you very much, Mr. Lady. Mr. Minor.
Well, Lord, what I'm proposing to do is just begin with our positive case, just to run through that and be clear what it is. And then before I go to the 3 grounds of appeal, I wanted to identify and address 3 points of difference between me and Mr. Bailey, because they affect all 3 grounds of appeal. The first is, what is it that belongs to the mortgagee and which is insured, and which is insured. The second point of difference is, what is meant by owners' policies? Do they include the non-existent December cover? And the third point of difference is, what is the nature of the policy? And I'm going to deal with those 3 points, which will take me a little time, but having dealt with them, I think answering the 3 points of appeal become very much accelerated. But the first part of my submissions is just to be crystal clear about what my client's case is. And can I ask you, and I'm afraid this won't be either certainly won't be the last time, page 163, which is the policy wording, just to have that open, please. And to remind you of the, I think, 6 stages which we accept that we have to go through in order to establish a liability on the part of insurers. Stage 1 is that mortgagees have suffered loss. That is the first reference to loss in clause 1.1. That's stage 1. And we have suffered loss because we used to have a mortgage over a vessel that had some value, and now the vessel is a constructive total loss. Stage 2 is that loss results from loss of or damage to or liability of the mortgaged vessel. And in this case, it wasn't a liability of the mortgaged vessel, it was loss of the damaged vessel. So that's stage 2. Stage 3 is that the loss of or damage to or liability of the mortgaged vessel would prima facie be covered by the owner's policies. And that means the owner's policies taken as a whole. Means all of them. And it has to be prima facie covered by those policies, and the relevant one here is the owner's war risks policy, and not excluded. So that's stage 3, that the damage to the mortgage vessel would prima facie be covered and not excluded. Stage 4 is that although it is prima facie covered, it is not in fact covered. which is why there has been non-payment. There has to be a non-payment. And stage 5 is that the non-payment by the underwriters of the relevant owner's cover is as a result of what is described as a, quote, insured peril. So, but in respect of which there is a subsequent non-payment, that's stage 4. As a result of, this is stage 5, any insured peril. And then stage 6 is that such insured peril, so that means the reason for non-payment, occurs or exists without the privity of the assured. So that's the 6th stage. Now, I think it is fair to say that stages 1 to 5 are in fact common ground. And it's only at stage 6 that Mr. Bailey says, oh, well, there was, the insured peril occurred with the privity of the assured. So that gives rise to the privity defence. And then Mr. Bailey has 2 sort of freestanding general law of insurance defences, which say that despite this analysis based on the text of the insuring clause being right, actually I can't recover. I think that's the structure. One observation to notice the way in which owners' policies are written. The war cover might have been structured so that it insured the vessel only so long as she was not in a war zone. It might have been written that way round. That's not the way war risk policies are written. Instead, it did what war risk policies traditionally do, which is to cover the vessel everywhere, but to extract a warranty from the owners that the vessel would not go into a war zone. And actually, that difference, that choice about how the war risk policy is structured, is the vessel covered everywhere, subject to a warranty, as opposed to being covered only when not in a war zone, is critical to my case. It's important because the insuring clause covers loss and damage to the vessel, which would prima facie be covered and not excluded. And if it is the case that Malone and Friends underwriters feel they didn't charge enough premium for this type of policy, well, perhaps it arises because of that feature of the interaction of the MII policy and the all risks policy. But there can be no doubt about it, and there's no it's common ground that the reason the all risks policy doesn't respond is a breach of warranty. So, pausing there, if I'm right that this policy responds, we would suggest that you might think that is in fact obviously the just result. Because my clients, the mortgagees, have behaved entirely as a prudent, honest and responsible lender would behave. They have gone into the market to insure against the double contingency that the vessel is lost and owners' insurances do not respond as you would normally expect them to, or as the lender would hope them to. That's what they've bought. They've bought something to cover that double contingency. If the owner's policies respond, it's okay. They're not going to suffer loss because they have an assignment to the benefit of the policies. But what they're interested in is the double contingency. And of course, it's that double contingency that has happened here. So the very thing which they have been into the market to buy or to protect against, the very risk they've tried to protect against is the risk which has transpired, but still underwriters say they may not recover. And therefore it is important at a sort of helicopter level to note the concession, expressly, and we say correctly, made, that if the situation had been exactly as it was, except the mortgagees had known nothing about the plans that owners had to take the vessel into Ukrainian waters for the second time, in which case, of course, the owners or the charterers or whoever it was did not need to lie about the forged policies. If nothing had been said about it, Mr. Bailey agrees that the MII policy would have responded. So his position is that my clients have the misfortune of having been actively lied to rather than passively misled. And that is a strange result if it's right. And the second point, which emerges only today, is I think Mr. Bailey was inclined to accept that if the nature of the deceit had been to produce a forged document which suggested that the same war risk insurers were extending cover rather than a different one, then again my clients would be able to recover. Well, that seems a fine and surprising point to make the difference between recovery and not. Particularly, we would say, because it is or ought to be a matter of indifference to the MII insurers whether owners' policies, and there's a raft of them, of course, not just all war risks, it ought to be a matter of complete indifference to them whether owners put all their risk with the same insurer, the same underwriters or not. And similarly, it's a matter of complete indifference to my clients whether the owners place all their risk with one insurer or a range of insurers. What we're both interested in, both the MII cover and us, is what the owners' policies and club entries as a whole provide in terms of cover. So it would, in our submission, be very odd if the precise nature of the lie and who the insurers were made any difference. So let me turn to the first of the 3 points of difference. And the first point of difference is, what is it that belongs to the mortgagee and which is insured? What is the insured interest? And Mr. Bailey says, and this is his skeleton argument, it's core 24, paragraph 17.1, he says, the interest insured under the MII policy was the mortgagee's collateral security as loss payee and assignee of the owner's policies. And I hope I understand him correctly to say that that is the only interest that is insured under this policy. Now that was a shift from his pleaded position, because in the pleadings he had admitted our plea that underwriters underwrote cover of the mortgagee's interest as mortgagee of the vessel. That was, I'll give you the references, pleaded particulars of claim para 7, core 123, and admitted in the defence at para 8, core 139. But he changed his position. We say his new position is wrong and the judge was right. Now, I think probably trite law, but in the authorities...
It's a new position. It's not new in this court.
It's not new in this court. No.
No objection to you.
No, I don't take any... It's a slightly jury point.
It's a jury
but it's finished now. It's finished. It's a jury.
Well, we've had some on both sides.
Exactly. I think I had a little bit of credit. And maybe I've used it up.
You both had one review.
Yeah. So, sorry, that's the wrong bundle. In the authorities bundle, we know, this is page,
Sorry, what are we
tab 1, page 3, Marine Insurance Act 1906, section 14, quantum of interest where the subject matter insured is mortgaged, the mortgagor has an insurable interest in the full value thereof, and the mortgagee has an insurable interest in respect of any sum due or to become due under the mortgage. So clearly, that is, the mortgagee's interest is an insurable interest to the extent of the sum it protects. And we say it is that interest which this policy insures.
It's a security interest, you say, in the vessel itself.
Exactly.
Proprietary security interest.
Exactly. And I have 5 points which, in my submission, demonstrate or address the argument on this issue. The first point, which in my submission is fatal to the suggestion that what is insured is my client's interest as assignee of the owner's policies, is that that contrary suggestion simply makes no sense. What the owners get under those policies, they get. What we get as assignee or loss payee under those policies, we get. If the policies respond, that's fine. We don't need to insure anything. If the policies don't respond, having insurance of those policies or of our benefit under those policies won't help us at all. So in my submission, it's just conceptually meaningless to say that somehow we are insuring our interest under the owner's policies. That interest is whatever it is. What we are interested in is the circumstances not in which we lose that interest, but in which that interest is insufficient for our commercial purposes.
I wonder if you're slightly oversimplifying his case. His case essentially is that the interest is as loss payee or assignee of the owner's policies in the sense of the proceeds of those policies which would be recoverable but for the insured perils.
Yes, but
that's and that doesn't suffer from the deficiency you're now identifying.
Well, he says that the interest insured was our collateral security as loss payee and assignee of the owner's policies.
Yes.
The only thing we get as loss payee or assignee of the owner's policies is the benefit of monies that are paid out under those policies.
Yes, but his case is what's being insured is the extent to which you don't get them because of one of these insured perils.
Yes, but that is not our interest under those policies. Because the reason we're not getting that money is because it's money that isn't due under those policies. So if you stop and say, what is it that I am protecting? What I am protecting is my interest as mortgagee, and the circumstances in which I'm protecting it are circumstances in which the existing policies don't respond. But that does not amount to an insurance of our interest under those policies. It is insuring something else. And so we would say that the only way in which the whole idea of somehow insuring our interest under the owner's policies would be if perhaps we insured against the risk that owner's insurers didn't pay a valid claim, or we insured against the risk of insolvency of the owner's insurers. But that's not what this policy is about. This policy is about the circumstances in which, on their face, the owner's policies don't respond and they can't recover. So that's the first point, that the whole concept of that the interest insured under this policy is our collateral security as loss payee actually, on analysis, doesn't make sense. The second point is that Mr. Bailey's reliance on the recital, because I asked rhetorically what are the arguments he makes. Well, he says, see the recital and the insuring clause, and he takes us back to the bundle at page 63. Well, the recital on page 163 simply says, whereas the assured has entered into a loan agreement, commensurate with which the assured holds certain collateral security, including first mortgage on the mortgage vessel, and endorsements of its interest on the owner's policies and club entries, that is neutral. It doesn't help in answering the question, what is it? What is the owner's interest that is insured? It refers to both features of the arrangement, that is to say the fact that we are mortgagee and the fact that we are loss assignee, but it doesn't help you decide as between them what it is that is being insured. The third point is that, in fact, all the indications in the policy wording are that it insures the mortgagee's interest qua mortgagee. The clue is in the name. This is mortgagee's interest insurance. It is not insurance policy assignee insurance. And the second clue comes from page 158. Where under the risk details, just up from the bottom of the page, the interest is described as mortgagee's interest insurance. And then there's mortgagee's additional perils, pollution insurance. We don't need to trouble about that. So the policy is named, we would say, in accordance with what it actually does, which is insures the mortgagee's interest. The fourth point is an argument from surplusage. If you go back to page 163 and clause 1.2.2, the indemnity payable is the lesser of two amounts, and the second of the caps is the amount of the unrecoverable claim or part thereof under any of the owner's policies and club entries. Well, if that was all that was being insured in the first place, it's unclear why you would need to put a cap on recoverability in the same sum. Now, my fifth point is to rebut some arguments made in writing by Mr. Bailey, not so much developed today, but below and in his skeleton, he relies on what's said in Colinvoe and Merkin and what is, in particular, said in Colinvoe in reliance on the decision in the Piraeus. This is a decision at first instance of Mr. Justice Carr. So, can we go to Authorities tab 24? Merkin used to say that mortgagee cover it insured the mortgagee's interest. And after this case was decided, it said it covers the mortgagee's interest, and it also said it covers their interest as assignee of the policies. And we've put in and referred to those. So it's quite important to see whether Piraeus Bank has any bearing on our case and on our wording, because it was said in the Piraeus Bank case that the interest insured was the interest under the policies. But the policy which was in issue in Piraeus Bank was on very different terms to our policy. First of all, if you go to 577, so this is the first of three differences in the wording. You will see at paragraph 229, under coverages, the Piraeus Bank wording lacks the double reference to loss, which we have. It said this insurance to indemnify the insured for loss of or damage to or liability arising in connection with the vessel, which is prima facie covered by. So it didn't have the double reference to loss. That's the first point. It also did not have the reference to losses not excluded, not otherwise excluded. And most importantly, it does have a different wording in relation to interests. If you look in the judgment at paragraph 15, you will see that in the Piraeus Bank case, the MII policy also contained the following definition of interests. That's bundle 546, judgment para 15. The MII policy also contained the following definition of interest. Interests, mortgagee and/or lessors and/or innocent owners' interest as assignees and loss payees under the owner's policies and club entries. Now, given what is said in paragraph 15, it may not be surprising that in this case, the judge said, and this is at page 578, paragraph 231, he said, I consider the following sets out the correct approach to the coverage arrangements in this case. He said at Romans 5, the right-hand column, the interest insured is the bank's interest not as mortgagee, but its interest as assignees and loss payees. Now that was below what Mr. Bailey strongly relied upon. We say it was obiter, it went by concession, and in any event, it depends on the wording of clause 15 in that policy, which is different to our policy. And it didn't matter for the result. Nothing in the result of this case depends on that. So we say that Piraeus can, in a sense, be set to one side. It's under different wording, and whatever is said is, in any event, obiter. And what is important is the proper construction of our policy. And all that is said in the textbooks to any contrary effect about interest depends on the Piraeus. If one sets aside the Piraeus, there is no suggestion that the insured interest is as loss assignee. So, does it matter? The learned judge below thought it didn't probably really matter what the insured interest was. Does it matter in the sense that it is the point on which the entire case turns? No, it doesn't. But Mr. Bailey's arguments are even more difficult if it is right that the interest that is insured is the mortgagee's interest. And we say the interest that is insured is the mortgagee's interest. That is interest as mortgagee, and that is the only thing that makes sense. Second point of difference. Second point of difference is, what are the owner's policies? I can take this very quickly because there was an exchange between the court and the bench on that. Mr. Bailey says in his skeleton that the December additional cover was the primary policy providing prima facie cover for the casualty. We say with respect that's nonsense. It would have been one of the owner's policies had it existed, but it didn't exist. We accept, of course, that the lies told about it form part of the factual narrative, and in fact explain how it came to be the case that the vessel sailed into Ukrainian waters for a second time without complaint or objection from the claimants. Whether it would have made any difference if we'd objected anyway, well, the judge thought not. But we accept that the lies told about it are part of the narrative, but we do not accept that it is, for the purposes of reading the policy, an owner's policy. And it can't be an owner's policy because those are defined at Clause 2.2 of Core 165, owner's policies and club entries means hull and machinery policies on terms equivalent to blah, 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 but it is obviously talking about actual policies of insurance, not something which is a figment of somebody's imagination. So that is a short point, and I don't think I can improve it by expanding on it. Then the third point of difference, and this is certainly informed by the first point of difference. The third point of difference is, what exactly is the nature of the policy, and did the judge misunderstand the nature of the policy? How should one characterise the key features of this MII policy? And I'm going to suggest that it's because Mr. Bailey, paragraph 17 of his skeleton, has set out his reading of it, I thought it might be helpful to identify where we differ from his analysis. So we will, in a sense, need to have both his paragraph 17 and 18 open, and also, and they are in core bundle pages 24 to 26, but also our favourite page, page 163, which has the policy on it. So, looking at page 163, and before we come to Mr. Bailey's submissions, the structure of the policy is, we say, that the assured is indemnified for loss to its interest as mortgagee resulting from loss of or damage to or liability of the vessel, but only if, and this is the second contingency, but only if, and that's the word, work is done by the word which, but you could read it as but only if, that loss of or damage to the vessel, that means the second reference to loss, is prima facie covered by owner's policies are not excluded, and is not in fact paid as a result of an insured peril. So there is, in a sense, a double contingency, and each contingency itself has two parts. The first contingency is that loss has been caused to mortgagees by loss of or damage to the vessel. So that's the two parts of it. Loss to the mortgagee's interest caused by loss of or damage to the vessel. And the second contingency is that the loss or damage to the vessel must satisfy this additional, slightly complicated requirement, which is, put broadly, no insurance payout, which is not quite as simple as that. It has two limbs. The loss was prima facie covered and not excluded, and, or but, payment is not made under the insurance by reason of an insured peril. So notice that neither the quotes insured peril on its own, nor loss or damage to the mortgagees on its own, and a fortiori, not loss of or damage to the vessel on its own, none of those on their own are sufficient to trigger the indemnity. All the elements are necessary conditions, but they must all be present together to enable mortgagees to recover. Indeed, the quotes insured peril, of which there's a list, but they're all things to do with why the underlying policy doesn't respond. The quotes insured peril, on its own, can never in and of itself cause loss to the mortgagee. The mere fact that there's a breach of warranty doesn't cause loss on its own, because that has to be combined with damage to the vessel causing loss to the mortgagee's interest and non-payment under the owner's policy. So, I mean, it's not straightforward, but at root there is this double contingency, so that the insured interest is the mortgagee's interest. It's protected against loss of or damage to the vessel, but only in some circumstances, and those circumstances are where the owner's policies do not respond. And so one has to be just a little bit careful about insured peril, because it's used in the wording here as part of the definition of the second contingency, but that doesn't mean that's the only way insured perils come into this policy. That in the first contingency, the insured peril is loss of or damage to the vessel. And that's why you've got to be quite careful about asking what was caused by the or a insured peril, because there are insured perils lurking within both contingencies. So that's what we say about it. Can I compare that with what Mr. Bailey says about it? So he says at paragraph 17, starts at paragraph 17.1, and he says the interest insured was the mortgagee's collateral security. And for the reasons I've already given, we don't agree with that. That's not right. 17.2, the MII policy is not a conventional first-party property insurance, blah, blah, blah. Well, we agree with that. This is quite a complicated beast of insurance law. So he's right, it's not a conventional first-party property insurance.
So you're saying it is a first-party property insurance, but it is not a conventional
Well, it's certainly not a conventional
Is that what you're saying?
I'm saying it is not a conventional first-party property insurance where the appellant promises simply to prevent or hold the assured harmless against all loss or damage to the vessel. It's more subtle than that.
Well, even without the second contingency, that wouldn't be an apt description.
Exactly,
of
because
the mortgagee's interest policy, because it's the security interest.
Exactly.
Not the value of the vessel.
And that raises questions. Your Lordship had one example, that the vessel has no value in the first place, and it's damaged, blah, blah, blah. What about, I've lent 5 million against a vessel worth 20 million, and it sustains loss which costs $1 million to repair? Have I sustained loss to the mortgagee's interest? I'd be recovering. I'm covered comfortably anyway. So there's been loss of or damage to the vessel, but there may not have been loss of or damage to my interest as mortgagee. So both in the very comfortable position and also in the very uncomfortable position, though that double reference to loss has some work to do, we say. 17.3, loss of or damage to the vessel is a necessary but insufficient occurrence. We agree with that. The 17.4, we also agree with the relevant loss insured is the mortgagee's net loss. And it's not, given that that's right, it's not easy for that to be aligned with the idea that the interest which is insured is something different.
Well, it's not quite net loss as defined in the policy. Net loss as defined in the policy is only one of the two limbs.
Exactly. Yes. Well, I think there are perhaps two slightly different questions. One is, what is the interest which is insured? What is the loss you are insuring for? And the second is, how much can you get when you sustain that loss?
Well, are they different? This insurance will indemnify the assured for loss. And then there's something which defines the measure of indemnity.
Yes.
It's 1.2 not defining what's meant by loss in 1.1.
Well, I'm not...
the way the word's used the first time.
No, I'm not sure that it is, because supposing I've lent 3 million against the 5 million vessel, and it becomes a CTL. So my loss at the top is going to be 3 million, but I can't recover, and that is the interest I'm insuring, but I can't recover it if the owner's policies would only ever have returned 2 million. So that caps what I can recover.
Just say that again.
Yeah.
It's my fault.
Let me try. We'll take a vessel worth 5 million. I've lent 3 million against it. It sustains a total loss. So my loss is 3 million. But the owner's policies, perhaps because there was an under-declaration of value, only give owners 2 million. Owners recover less, much less than the true value of the vessel. I mean, it doesn't happen very often that way round, but suppose it were the case. They only recover 2 million. I can only get 2 million under my MII policy cover because my recovery is the lesser of those two sums.
But that's because 1.2 defines the measure of indemnity, so that when in 1.1 it says this insurance will indemnify the assured for loss, 1.2 identifies what that loss is for which the insurance will provide indemnity, doesn't it? It's not. Well, it's not different. We don't have two separate stages. The loss under 1.1 is the loss which this insurance will indemnify for. And that's defined in 1.2.
Well, except where you have a clause which says what you can get is the lesser of two amounts, is that putting a cap on what you can get, or is it saying what loss is prima facie covered? We would say that's putting a cap on what you can get. The interest which is insured is the value of the mortgagee's interest, but you can't necessarily recover all of it because you can only get the lesser of your net loss, that is your lending loss, because after all you might have made that good somewhere else, and the the amount which owners get under their insurance.
But the value of the damage to the vessel, if I can put it in that way, isn't actually directly an element of either of the limbs of the measure of indemnity. I quite accept, of course, that the security interest may have a bearing on both, but you're not talking about prima facie recovering the diminution in value of the vessel that's caused by the damage and then putting a cap on it in one or other of two ways. You've got two measures. One is the outstanding amount of the loan, if I can put it crudely, and the other is the amount that would have been recovered under the owner's policies.
Yes, but if you asked
neither of those is directly the security interest in the vessel.
No. I mean, perhaps it's a slightly semantic difference, but we would say 1.2 puts a limit on the indemnity, and you won't know which is the operative limit till you run the numbers. So it would be odd to say that defines the nature of the loss insured, because which you recover depends on which is lower. We would say the starting point is what I'm insuring is my interest qua mortgagee, but towards losses sustained qua mortgagee, I can only recover a sum which is capped at the lower of these two figures. So certainly our preferred construction would be this is a cap on the recoverable amount, rather than going to define the interest which is insured.
Yes, the question is what's the loss insured, not necessarily what the interest insured. That's what I was putting to you.
Yeah.
You say it doesn't define the loss insured for the purposes of 1.1 loss in the first line.
Yes, but it puts a cap on how much you can recover towards it. I mean, it's quite a fine point, and I'm not sure that it matters. But anyway, you have my submissions. Next paragraph from Mr. Bailey is 17.5. And he says the mortgagee's net loss resulting from non-payment under the owner's policies must be approximately caused by a named insured peril. And it seems to us that that's not quite precise and accurate. It is the non-payment under owner's policies that must be approximately caused by the insured peril. The insured peril, in other words, causes non-payment under the policy. But it's not the mortgagee's net loss that must be caused by a named insured peril. The mortgagee's loss is the loss it sustains to its interest qua mortgagee because of loss of or damage to the vessel, and it can only recover that if and insofar as it would have been covered under the underlying policies. And that, perhaps slightly subtle point, is quite important when you start asking the questions, what loss is it that the, quotes, insured peril must cause? And that goes back to the point about the first level of contingency sort of concealing an insured peril which is not made explicit. So this second reference, it's obviously textually the first reference to insured peril, but if you think about the fact that there is an insured peril in the first contingency, this second reference to insured peril is talking about an insured peril which causes non-payment under the owner's policies. Uh, 17.6, there's only cover under the MII policy if the relevant insured peril occurs or exists without the privity of the assured. That's right. That's exactly what the policy says. 17.7, the insured perils are specifically defined. Yes, as long as one realises that one is talking about the reference to insured peril under the second contingency part of the policy, then we accept what he says at his 17.7.
But does it follow from your submissions that what are called insured perils are not what would normally be called insured perils in marine insurance, i.e. Those risks which have to approximately cause the loss?
They're certainly not on all fours. I mean, I accept that the insured peril in the second part of the wording here, the specified insured peril, must be the proximate cause of the owner's policies not paying out.
Because that's what result from normally means.
Exactly. So I accept that. But is it on all fours with insured peril in a normal policy of insurance? No, it isn't, because it's part of that limiting second contingency. But I've no problem with the proposition that the inverted commas insured peril must be the proximate cause of owner's policies not responding. But it doesn't make any real sense to say that that, quote, insured peril must be the only proximate cause of mortgagees' loss to their interest qua mortgagee. That's making it do far too much work and ignoring the fact that there's a double set of contingencies here.
So just to be clear, and anticipating where you're going back to the first line of 1.1, you say that approximate cause test applies in relation to the resulting there as regards the loss or damage to the vessel.
Yes.
And that, in effect, is an insured risk at that stage.
Yes. An insured risk and insured peril. Yes. And then Mr. Bailey at 17.8, I agree with. The risk of non-payment because an owner's policy is null and void ab initio, and the risk of non-existent primary cover is borne and retained by the mortgagee. I accept all that. But of course it's very important what you mean by owner's policy. And it must mean an actual owner's policy, not an imaginary owner's policy. 17.9 is correct, but I think irrelevant. And 17.10 is wrong. 17.10 is wrong because the imaginary December cover was not an owner's policy or club entry. And then he summarises at paragraph 18, but we think this isn't quite right either. He says, in short, the risk of a loss to the mortgagee as a result of loss of or damage to a vessel and the non-payment by the relevant owner's policy is retained and borne by the mortgagee unless, and this is where it goes wrong, unless the proximate cause of that loss is one of the insured perils defined in clause 2.1. It would be right to say, unless the proximate cause of that non-payment is one of the insured perils defined. That's right. But you've got to be very careful using the word loss as a generality in this double-tiered two-contingency insurance clause. So that's what I wanted to say about the three areas where Mr. Bailey and I differ in terms of introductory but very important issues. So I can turn to ground one, which is causation. And we say that once one is armed with a proper understanding of the policy and how it works.
Sorry, can I just, before
Yes.
we leave that, so that if you were wrong in your submission about loss when it's first used in 1.1, meaning measure of indemnity under 1.2, just stay with me for a moment, I know you don't accept that.
Yes.
Your case would still be that there are two relevant insured perils or sets of insured perils. There's the insured peril from the first line of loss of or damage to or liability of the mortgage vessel, and there are the insured perils in 2.1, some of which, which apply to one of the two measures of loss, which is what is indemnified under 1.1, but not the other. Is that how it would work? So you'd have, if I was trying to look at insured perils in the conventional sense of something which must approximately cause a loss, they must approximately cause loss or damage to the vessel, and they must approximately cause the element of the loss which is the amount of the unrecoverable claim in the contingent circumstances, but not 1.2.1.
Yeah.
One's got, in some senses, one's got a double contingency with insured perils that don't depend on each other. But in another respect, you've got, if the only measure of loss were 1.2.2, you would have two sets of insured perils which had to operate cumulatively, both loss or damage to the vessel and irrecoverability under the conditions that.
Oh, but we do have to show both. I mean, I accept that we have to show both.
Yes, but they would both be insured perils being proximate causes of the loss. If the loss defined at the beginning of 1.1 is as defined in 1.2, and if, which isn't the case, the loss under 1.2 were only 1.2.2 rather than the lesser of 1.2.1
Yes.
and 1.2.2, so that one's got a hybrid in that you've got two alternative measures of loss, one of which involves the loss being caused by the operation of two insured perils, and one of which is a measure which only requires the operation of one insured peril.
I'm not sure that I would put it quite like that, because I accept that I can.
No, I'm sorry, that doesn't work because the proviso is in the body of the clause.
Yeah.
Okay, thank you. Helping me clear my mind.
So on to causation, and this is Mr. Bailey's skeleton 23 and onwards. We could just turn that up. And the summary of it is at the beginning. It goes without saying an assured loss must be proximately caused by an insured peril if it's to be recoverable. Proximate cause is not the first, the last, or the sole loss. Cool. And then at 24, the proximate cause of the respondent's loss was the invalidity of the December additional cover which the respondent approved in writing and relied upon as a primary policy that was supposed to provide prima facie cover for any loss of or damage to the vessel. So I have to, I think, address both the paragraph 23 submission and the paragraph 24 submission. So the paragraph 23 submission is it goes without saying. Well, we don't quite accept that because the Marine Insurance Act, section 55, I think this is the point which the court made earlier, says that unless the policy provides otherwise, we can look at the provision and it's in the authorities bundle at page 5. Subject to the provisions of this Act, and unless the policy otherwise provides, the insurer is liable for any loss proximately caused by a peril insured against. And that is all about causative potency and the presumed intention of the parties. And we get that from the Arch case, which is in the authorities at 494, and I think it probably is worth seeing what the Supreme Court said about that. We go in the authorities bundle to page 493, so it's FCA and Arch 2021 appeal cases 649. And at para 162, they deal with proximate causation. Many different formulations may be found. At letter H, although the question whether loss has been caused by an insured peril is a question of interpretation of the policy, it's not a question which depends to any great extent on matters of linguistic meaning and how the words used will be understood by an ordinary member of the public. What's at issue is the legal effect of the insurance contract as applied to a particular factual situation. And then at 163, dealing with section 55 of the Marine Insurance Act, like other provisions of the Act, it's treated by the courts as also stating the law applicable to non-marine insurance. As is clear from the words, unless the policy otherwise provides, however, the rule is not inflexible. The requirement of proximate causation is based on the presumed intention of the parties, but it's a presumption capable of being displaced if on its proper interpretation the policy provides for some other connection. Now, as I've already made clear, my point here is not a point about proximate cause as opposed to any other sort of cause. It's simply to say there are different proximate causes operating at different levels within the insuring clause. So that at the first level of the insuring clause, the proximate cause of my client's loss was loss of a damage to the vessel. So we say the proper approach to cause here is question 1, what is the proximate cause of Oceanus's loss? That is to say, damage to their interest as mortgagee. And the answer to that question is the mine strike, as the judge held. And I think we're agreed that the second causative question is, what was the cause of the fact that the owner's policy did not respond despite there being prima facie cover? And we're agreed that the answer to that is obviously breach of the warranty. So there were 2 proximate causes of elements which combine to mean that my client can recover.
So is the first of those, what is the cause of loss or damage to the vessel? Or
Well,
what is the cause of loss to the security?
Loss, I think you've, if I may say so, corrected me correctly. What is the proximate cause of Oceanus's loss? That is to say, damage to their interest as mortgagee. And the answer to that is damage to the vessel caused by the mine strike. But I think one could say, probably fairly safely, and therefore the mine strike was a proximate cause of the mortgagee's loss. Because a series of things, one of which causes another, can all be proximate causes.
But that arises simply irrespective of how one characterises, which we spent a lot of time on, the nature of the policy or in particular the interest being insured. You say that simply follows from the initial wording.
I agree.
That there must be loss of or damage to the vessel.
I agree. And I mean, I think that is why the learned judge at first instance said that she was not persuaded that it actually mattered what the technical nature of the insured interest is, and it's why my submission was that it's not the turning point in the case, but that addressing it is helpful. And I think in the discussion between the bar and the bench earlier about fortuity, we can see that there are echoes of just being clear what it is that needs to be fortuitous, and is it damage to the insured interest? Because if it's damage to the insured interest that needs to be fortuitous, one can get that fortuity from the mine strike and the damage to the vessel. So it's not the turning point, but in our submission it's helpful and a good idea to be clear what is being insured. So that's sort of our case of causation, and we say that the judge therefore got it right. Now, Mr. Bailey's case on causation is that, and it's his paragraph 24, the proximate cause of the respondent's loss was the invalidity of the December additional cover, which the respondent approved and relied upon as the primary policy that was supposed to provide prima facie cover for any loss. That's not an insured peril under the MII policy, and the respondent's claim should have failed on that basis. That's the way it's put by Mr. Bailey. And I mean, he rightly says that the invalidity of an owner's policy which never actually incepted and never existed is not an insured peril. We go that far with him. That is right. But this is a question of what caused what. Notice, first of all, that Mr. Bailey has a very high hurdle if he is to succeed on this point. Because where there are two proximate causes of loss, one covered and the other not mentioned in the policy, i.e. not expressly excluded, the insured recovers. It is only where there are two proximate causes of loss, one covered and the other expressly excluded, that the claim fails. So, and I think this is now trite law, but it's Arch, paragraphs 171 to 176. Now, Mr. Bailey, therefore, has to show not only that the invalidity of the December additional cover was a proximate cause, but he would also have to show that there is no other proximate cause. Because if there are two proximate causes, and he's not suggesting that my proximate cause is expressly excluded, it wouldn't help him anyway, even if he could persuade you that it was right to treat the invalidity of the December additional cover as a proximate cause. It wouldn't help him unless he could show there was no other proximate cause of my client's loss. Because he's not saying that the proximate cause that I rely on is an excluded clause, and it obviously couldn't be.
But aren't those principles dealing with the situation where there are two sufficient causes, which is not really what we have here? Because neither of your proximate causes in this case is sufficient by itself.
I'm not sure that a proximate cause has to be sufficient in and of itself, because we know from Arch that it need not actually even be a but-for cause, which is why all the outbreaks, none of which were but-for causes, could all be proximate causes.
No, but I think the point my Lord's making is that sufficiency, by whatever test is, needn't be but-for, but on its own would be treated as a proximate cause of the loss, whereas you may have here two sequential links to proximate cause, in which case we've got to make out both of them.
Well, I
mean, if you couldn't make out proximate cause in relation to the insured perils causing the non-responsiveness of owners' policies,
I'd be dead in the water.
It wouldn't help you. But one of your two proximate causes you're identifying is damage to the vessel.
No, I agree. I think.
So
yes.
The analogy you're drawing, for the reasons my Lord gives, may not be a sound one. One excluded, or one not mentioned.
No, but what I understand Mr. Bailey's argument to be is that if he can show that the invalidity of the December cover was a proximate cause of my client's loss, he's home and dry. And he seems to be suggesting that it is the only proximate cause of my loss. And I say, well, he couldn't possibly regard it as the only proximate cause of my loss. And if it's not the only proximate cause of my loss, he can't succeed unless my proximate cause is expressly excluded.
Well, I understand that's what you're saying, but I'm not sure that meets my Lord's point about the rules on excluded or not mentioned losses.
Okay, I shall think about that, if I may. In any event, we say that the non-existent December additional cover did not, in any true sense, cause anything. It wasn't the proximate cause of our loss. We're not suing for the non-responsiveness of that policy. And although, as I've already said, what happened in relation to that non-existent policy forms part of the narrative, so that it provides, in a sense, the occasion for the loss to be suffered, it is a very long way away in causative potency from causing any loss to us. The real loss to us is caused by the mine strike. We just wouldn't be here without the mine strike. That has the causative potency.
To which Mr. Bailey says, well, we wouldn't be here either if the December policy had been a real policy.
We wouldn't be here either if the December policy had been the real policy, but I would have still have sustained the prima facie loss. The only difference is I wouldn't have had any trouble recovering for it. But the loss would have been the same. The proximate cause of my loss, which is instead of having a mortgage over a decent vessel, I've got a mortgage over a vessel at the bottom of the river, that's the same. And it's very odd, it seems to us, to say that a loss is caused by the fact you don't have insurance. If I sustain a loss to my interests, and it might be insured or it might not be insured, but I sustain the loss. If it's insured, okay, I'm happy. I've been indemnified for that loss. If it's not insured, is the lack of insurance the cause of my loss? No. The lack of insurance is the cause of the fact that I'm not indemnified for my loss.
If the December additional cover note had evidenced genuine cover, am I right in understanding then you say that quite apart from the right to recover on that insurance from different underwriters, you would not have been able to recover on this policy if you chose not to claim that, because it would have been an owner's policy, and this policy, the MII policy, only responds if there isn't cover under any of the owner's policies.
Yes.
But if, conversely, what the mortgagees had decided to do was to take out additional insurance cover themselves, to cover the casualty, you would say that would be res inter alios acta. There would still be cover under the MII policy, and the fact that they'd also taken out insurance is neither here nor there. If they chose not to claim on that, you would say, would you? The MII policy still responds. All the provisions are fulfilled. That wouldn't be an owner's policy.
I think my first answer to that question is I'd like Robert to think about it.
It may not matter, but I just...
No, but it is interesting. I mean, I wonder whether it's answered by the whichever is the lesser amount, and that I couldn't recover because I wouldn't have sustained a net loss under clause 2.3.
Well, the premise is you haven't actually claimed on the other insurance.
No, but it's recovered or recoverable under all security arrangements contained in or collateral to the loan. Including but not, I'm looking at page 165. Including insurance policies. I think if it were recoverable under another policy, I would be stuck, which seems like it should be the right result. It's nice that there's a clause which deals with it.
Well, there might be questions of double insurance, I suppose.
Yes. Yes. But it doesn't... Yeah. It would seem very odd if I could recover, particularly given that provision. So that's essentially what I wanted to say about the causation point. There were just a few points in what Mr. Bailey says in writing about it, which I wanted to pick up. The first is his point at paragraph 30. So it's bundle page 31, Mr. Bailey's paragraph 30. He says, I think the second sentence, the risk that's being insured against is the risk of financial loss due to non-payment by the owner's insurance, which results from a double contingency, loss of or damage to the vessel that's primary face covered, combined with the failure of the owner's policies to respond. That's for the reasons we've been through, quite close to my analysis. But he says the relevant causal inquiry concerns the reason why the primary policy providing prima facie cover for the casualty did not respond. And we say that's just not right, not if that's a reference to the non-existent policy. That's back to that point. And again, paragraph 34, he says that the judge should have asked herself, would the respondent have suffered a net loss within the meaning of the MII policy following the mine strike had the December additional cover been valid as opposed to a forged policy? To which the answer was clearly no. But that isn't the question the judge should have asked herself. The question is not what might have happened in an alternative world where there were different policies, but how do the policies that are in place, how do they respond? You can't posit some alternative which is unreal, to say that in those circumstances there isn't a loss, and therefore in the circumstances which do sustain, which did happen, there is a loss. That's just a non-logical non sequitur, so it seems to us. Paragraph 44 really, in our respectful submission, goes nowhere. Mr. Bailey says that the December edition will cover was the first cover that owners and respondents looked to after the mine strike. Well, of course, believing it to be a genuine cover, that was the first thing they looked to. They weren't intending to look to the MII cover, of course not. But that really, again, is a jury point. It doesn't assist with the questions which actually arise under the policy. So that's, I think, all I wanted to say on causation, unless there's anything else I can help with. And I can therefore go on to privity. In the court below, there was a dispute between us as to whether privity meant merely knowledge or meant knowledge and consent, or sometimes knowledge and concurrence. Happily, that issue is now resolved, and it is common ground that to demonstrate privity there must be both knowledge and consent. Can we start with the Eurysthenes at tab 7, please? And this is a case, as you know, about privity in relation to unseaworthiness. In section 39.5. And if we go to bundle page 104, and this is Lord Denning at page 68 of the report, which is 1997 1 QB starting at 49. He says just below letter C, he set out the meaning we should attach to the word privity, and he says if the ship is sent to sea in an unseaworthy state with the knowledge and concurrence of the assured personally, the insurer is not liable for any loss attributable to unseaworthiness, that is, to unseaworthiness of which he knew and in which he concurred. And he says to disentitle the shipowner, he must, I think, have knowledge not only of the facts constituting the unseaworthiness, but also knowledge that those facts rendered the ship unseaworthy, that is, not reasonably fit to encounter the ordinary perils of the sea. And then he goes to deal with the quality of knowledge, and says it includes turning a blind eye. But the bit which I just wanted to focus on was a statement that needs to know not just of the facts which constitute the unseaworthiness, but of the unseaworthiness itself. And Geoffrey Lane, or Justice Geoffrey Lane as he then was, is to exactly the same effect. This is bundle 117, report page 81, starting just below letter D. For the owners to lose their cover, it must be shown the ship was sent to sea in an unseaworthy condition, and that was done with the privity of the assured. Privity means with knowledge and consent. It has, so far as I can discover, no connotation of fault. It's a neutral word deriving colour from its surroundings. One can be privy to a good scheme or privy to an evil scheme. Blah, blah, blah. But then he says at letter F, knowledge of what? Again, the subsection is clear. It says unseaworthiness, not facts which in the upshot prove to amount to unseaworthiness.
Can you just tell me, where do I find the actual section?
Yes. At the very beginning of the headnote. I think that's probably the most.
Yes.
Yes, that does look to be a convenient place
Yes,
to start.
right at the top.
Yes, I see.
Yeah. So I should immediately say that this is all about privity in a particular statutory provision, but our position has throughout been that it would be surprising if it had a different meaning in this insurance policy. I persist in that. So back on 117, so he said privity means with knowledge and consent, and then at F, knowledge of what? Again, the subsection is clear. It says unseaworthiness, not facts which in the upshot prove to amount to unseaworthiness. Accordingly, it seems clear to me that if this matter were res integra, the section would mean that the assured only loses his cover if he has consented to or concurred in the ship going to sea when he knew or believed it was in an unseaworthy condition. I add the word believe to cover the man who deliberately turns a blind eye. And then he says, well, there's one case which might lead to the contrary, but on analysis it isn't. Let him look at that. So we are dealing here, because my learned friend takes this privity point as a contractual point, rather than, I think, a general principle of insurance law point. He takes it as a contractual point arising out of the wording in the insurance clause. I don't think it matters very much, but it would be very different if it were otherwise. But the question is, does the insured peril occur or exist without the privity of the insured? And what is being said is that the sailing into UK waters which constituted the breach of warranty occurred with the knowledge and consent of the mortgagees. And that means that we need to think carefully about what is the insured peril of which we must have knowledge and consent. Is it being in breach of warranty? Is it being in breach of warranty by sailing into Ukrainian waters? Or is it sailing into Ukrainian waters? And it seems to us that since the insured peril is breach of, the insured peril relied on is breach of trading warranties, rather than sailing into Ukrainian waters, what we must be privy to is the breach of warranty. Or perhaps you might say we must be privy to the breach of warranty by sailing into Ukrainian waters. But it can't be sufficient, in my submission, to be privy merely to the sailing into Ukrainian waters. So we said in substance, we are content for you to sail into Ukrainian waters, but only if you have got war risks cover when you do so. Because, not expressed but obvious, because in that case there will be no breach of warranty.
But there would be a breach of warranty.
No, we said we are content for you to sail into Ukrainian waters, but only if you have extended cover.
Well, you mean if you have war risk cover, because if that were extended cover,
yes,
there would be no breach of the war risk policy.
Exactly.
And if it were separate cover, that would be an owner's policy.
Exactly.
And that
exactly.
And that would be sufficient.
Exactly.
So war risk cover generally.
Yes.
Is I think the point you're making.
Yes.
Just tell me again the point you are making. So I'm absolutely...
The point I think I'm making.
Yes.
I'm saying what we said in substance was we are content for you to sail into Ukrainian waters, but only if your insurance arrangements are such that that is not a relevant breach of warranty.
You're taking issue with Mr. Bailey's analysis, which was that if the December additional cover were valid, there would still be a breach of warranty,
Yes.
but it would not be one which was causative of loss because there would be a remedy under the new additional cover.
Exactly. Exactly. I say if you look at what the MII policy as a whole is intended to do, it is directed to the package of owners' policies. It is directed to the circumstances in which, for reasons which are the fault of the owners, the package of policies does not respond.
I entirely follow the commercial logic of that. I can also see how it can be said with force that any consent to you might otherwise be thought to have given was vitiated. But you are relying as your insured peril on the failure of the war risks policy to answer, as I understand it.
We are relying on the failure of the owner's policies.
Well,
as a whole.
specifically, are you not relying, because you say the other policy didn't exist, so you're relying on the fact that the main policy did not respond because of breach of the trading warranty in respect of it. And
Yes.
you did go along with the vessel entering into Ukrainian waters, knowing that that would be in breach of that warranty.
Well, knowing we consented, or at least we didn't actively object. Consent's perhaps a bit different. We certainly did not actively object. We ceased our active objection because we thought that the quality of the act, that is to say going into Ukrainian waters, did not in any material sense constitute a breach of condition, a breach of warranty. Because taking the owner's policies as a whole, as we thought they were, it wouldn't.
So you're saying this, are you, that you were not privy to any breach of the trading warranties because you believe that there was war risks cover and therefore no breach of trading warranties, taking account of the package of policies as a whole, including the December cover.
Exactly. So that the breach of warranty did not occur with our consent.
But it does then depend on taking them as a whole, because the breach of warranty in relation to actually the effective policy certainly did occur with your concurrence.
Well,
Subject
the
to initiation.
fact which constitutes it occurred with our concurrence. But we did not think it was a material, operative, or relevant breach. We didn't consent to those things happening because we thought, it'll be nice that we can claim under the MII policy. I mean, quite the contrary.
You didn't consent to owners' policies failing to respond for breach of trading limits. You did consent to this one failing to respond on the footing that there was another policy that would respond.
I suppose that's right.
So,
Yes, I suppose that's fair. So perhaps there isn't consent at all. That's the argument I've just been making, or perhaps there's consent, but it's vitiated. It's not effective consent. As to that, it doesn't seem to us that cases about criminal offences, particularly where a lack of consent is part of the offence itself, and particularly where there's statutory provisions about consent in the Sexual Offences Act, are really going to help the court very much at all, save by the most general of analogies and rather weak analogies at that. But what we say is more relevant is to think about the role which generally privity is intended to play in the law of insurance, which we say is to act as a control on people who have insurance and are in some sense abusing it. They are bringing a claim in circumstances where the very grounding of the claim is something in which they concurred. And the very grounding of the claim here is not something in which we concurred. Now, Mr. Bailey says, well, it can't be right that breach of a condition, the condition here being you must get extra insurance, it can't be right that that necessarily negatives consent. He says, well, what about if we give consent subject to the vessel only steaming at 5 knots? And it's worth pausing and considering that, because why that's different to our case. In those circumstances, we know that an act is about to happen, that is to say, sailing into Ukrainian waters, which will constitute a breach of the trading warranties, in this hypothetical example. That is to say, nothing's being said about additional insurances. We consent to that breach on condition that the vessel steams at 5 knots. The vessel then goes into Ukrainian waters, breaching the trading warranties, and steams at 7 knots. Well, obviously, we have no answer to the suggestion that we were privy to the breach of the trading warranties. Because in those circumstances, we consented to something which we knew was going to constitute a breach. In other words, the condition there is totally unconnected from the breach with which we are said to be privy. Because after all, in those circumstances, what would our real complaint be? Our real complaint would be, well, you steamed at 7 knots instead of 5 knots. Why has that got anything to do with whether we're then privy to the breach of the trading warranty? It's got absolutely nothing to do with it. Bit like the sex worker who has sex and then isn't paid the £200. What's their real complaint? Their real complaint is they haven't been paid the £200. That's the real complaint. What actually happens in our case is, we know there's going to be a breach of the trading warranties unless something happens, a relevant breach of the trading warranties taken as a whole under the owner's policies. We know there's going to be a breach of the trading warranties unless something happens. We are told that something is going to happen, namely a policy extension, which means that there won't be a breach of trading warranties. And on that promise, indeed on the promise that that has happened, we consent to the action of sailing into Ukrainian waters because we've been deceived into thinking that it doesn't constitute a breach. So, unlike the 5 knot example, in the real world, in what actually happens is we consent to something which we don't think is a breach of the trading warranties taken as a whole. And that is why the promise which induces the consent or lack of complaint is absolutely central to the nature of the act. The lie goes to the essential nature of the act. Our interest, insurance, in an insurance sense, what we are interested in is whether the proposed voyage has war risk cover or not. We're told it will, so we don't object to it. In fact, it won't. The deceit is absolutely fundamental. And so we say in those circumstances, that vitiates any consent that might otherwise have been.
Well, it's fundamental to whether the vessel goes there without war risk cover. It's not fundamental, and indeed not relevant at all, to whether she goes there without war risk cover under the policy that actually is what gives rise to liability on the MII policy. And that's the difference between you.
Yes.
I mean, you use expressions such as fundamental or central to or whatever, but although I quite understand you say that the sexual consent clauses of a particular kind and arise under section 74 and so on, is it inapposite to use a similar test, namely, is the deception into something which has a sufficiently close connection?
Well, in anticipation that might be the approach taken, I say that it's
that begs the question slightly as to what is sufficient, but that's that's if it's good enough for the criminal courts, it might be good enough for the civil courts. Who knows?
But my point in drawing the distinction between it's okay to go into Ukrainian waters if you steam at 5 knots, and it's okay to go into Ukrainian waters if you're insured to do so, is that the condition as to which we were misled is absolutely fundamental to the nature of the act. It makes all the difference between whether it is a breach or not. And if you go back and think about the unseaworthiness...
Well, a breach of what is the question? It makes no difference at all as to whether it's a breach of the policy, which is what you're in fact relying on for making the claim. It makes all the difference to whether there's a breach of the owner's policies taken as a whole.
Yes.
That's the distinction.
Yeah. And I think that goes back to the point which I made earlier, which is that it at least is or should or at least is or at least should be a matter of indifference to the MII insurance, whether the policies are or with the same insurer or not, or a series of policies, and it's a matter of indifference to me as well. That is something within the choice of owners. We can't do anything about it. We couldn't have stopped them getting a separate policy instead of a top-up policy. That's their business, our interest, and therefore we say MII insurer's risk. It looks at the response of the package of the policies as a whole.
Now we've reached a quarter past. Is this a convenient moment to break?
I think it's a very convenient moment, and I can just hone overnight what I need to say on fortuity and consider some of the points which the courts raised this afternoon.
My Lord, before you rise, and I didn't want to interrupt my own friend, but it seemed to be potentially important to point this out, given some of the submissions you've been hearing from my own friend. The learned judge did make some relevant findings of fact about what Oceanus knew. Paragraph 14 of the judgment, which is page 84, she records, in early December 2023, Williamson was informed by NAVA of a further intended trade into Ukrainian waters. It is common ground that Oceanus knew that this further trading would again be a breach of the trading warranties, and that if this occurred, the war risk policy would not provide cover. And then at paragraph 19 of page 86, she says, in cross-examination in relation to this...
Just before you go on to paragraph 19, I think I've got the wrong paragraph that you were quoting a moment ago. Which paragraph were you quoting a moment ago?
14, I beg your pardon, my Lord, I was rushing it.
Page
84.
I'm looking at the wrong document.
I'm so sorry.
Yeah.
Page 84 of the core bundle, paragraph 14, the second sentence. And then I was going to just briefly, I want to take you to paragraph 19, page 86. In cross-examination in relation to this further trading in December, Mr. Magelson accepted that he was chasing Lyra Mare and the charterer for the December additional cover because he knew that if the vessel traded in Ukraine, it would be in breach of the trading warranties and there would be no cover under the war risk policy. He was stated he had been told by Williamson that Oceanus needed the additional policy and so on, and we know what happened. And of course then there are findings made later, I think paragraph paragraph 74, page 113, set out above. Oceanus knew that the vessel was sailing to Ukraine and that would be a breach of the trading warranties. It knew that additional cover was required. Anyway, I wanted to raise those now in case it affects what my own friend wants to say tomorrow.
We'll leave it now and 10:30 in the morning.
All rise, people.